Good evening, good evening. How are you doing? So, this is Ifeoma Odunlami, immigration attorney from the Odunlami Law Firm in New Jersey. Hi, everyone. Come in, join me. Let's talk about an important topic in immigration. Thank you guys for joining me. Let me know where you're joining from. It's always fun to know where people are coming in from. All right. So, it's Monday and the start of a new week. I hope everyone had a great weekend. My weekend was great. I took my daughter to college, my second daughter. Oh, it was so emotional. They grew up so fast, but it is I guess, the rite of passage. So I'm back in the office today. I was off on Friday, taking her, settling her into college. But today I'm back, and I want to talk about I-751s, which is removal of conditions. So I did a consultation the other day, and the woman called my office all frantic, crying because her husband was threatening to divorce her and have her deported and take her, if she's deported, she's not going to be able to see her kids. And she was so frantic. And I said to her, well, you have a temporary green card, the 2-year green card. And she said, yes. And I was like, well, why are you so worried about him divorcing you? Because if he divorces you, that's not a bad thing, because you can still get your green card, your 10-year green card, even if your marriage doesn't work out. So that's what I want to talk about, because I get this calls a lot. People who are being terrorized by their spouses who give the impression that they are able to get them deported. So there are many ways to get your green card that does not require you to stay in an abusive relationship. You're not even required to be in an abusive relationship for any reason. So there's VAWA, Violence Against Women's Act. If you're in a relationship where you're being abused physically or emotionally, mentally, or psychological, you can file to get a green card through VAWA. The other way is, through a U visa. If you have if there's physical abuse in that relationship and you went to the police, and assault is a crime. As aggravated assault is part of the qualifying crimes in the U visa. But the good thing about the U visa is you don't need to be married to your abuser. In the VAWA case, you do need to be married. To remove your conditions, of course, you need to be married. But today I want to talk about the removal of green card, your conditions when you already have a temporary green card. So I'm going to start from the beginning. Thank you guys for joining me. Um, when you're married to a U.S. citizen or you're married to a green card holder, and the marriage is less than 2 years, right, at the time you get your green card, you will be given a temporary green card. That green card is only good for 2 years, right? Now, at 90 days before the green card expires, you're required to remove the conditions on the green card. And removing the conditions is a fancy way of basically filing the form I-751, which is a form that you use to remove the conditions, and putting in all the evidence to show that your marriage was a bona fide marriage, right? So that's what the removal of the conditions is. So you're supposed to do this jointly with your spouse. And when you do it jointly with your spouse, you're required to fill out the forms. Your spouse will sign a portion of the form. You will sign another part of the form. And then you have to submit evidence showing that it's a bona fide marriage. It was then, it still is. So a lot of people get the temporary green card and they feel that removing the conditions is not a big deal because they already got the temporary green card. I'm here to tell you that the I-751 removal of conditions sometimes is even more difficult to get approved than the initial green card. And the reason is because when you get married and it's a young marriage, immigration understands that you may not have a lot of the documents you're looking for. So say you got married and it's less than a year, you may not have gotten your work permit, so you're not able to work. You may not have filed taxes together because, the tax year hasn't come through. You may not be able to get on the lease because maybe you haven't received your social security number. So all of these things could tie into the fact that you're not able to provide certain bona fides, certain proof of a good faith marriage. However, when you get your temporary green card, you now have your work permit. You now are able to file, 2 years would have passed. You should have been able to file taxes at some point, and you should have more information to show that this is a bona fide marriage. So the burden really is higher when you're removing the conditions, because at this point you really have no excuse not to have this proof of a bona fide relationship. So so that's what is really important. You need to show that it's a real marriage. So the same things that you submitted the last time when you were applying, which is proof of financial commingling, proof that you have a joint account, right? And like I've said to you guys before, a joint account it's not enough to have a bank account that has both names. The account, the statements, the activities on the statements must show that this account is being used by two people. So if you have a statement that shows that that's only one person is using it, that's very suspect. Or you have a bank statement that doesn't have a lot of activities. You have $300 there. The next month, it's $300. A little, some money is spent. That's not really showing that both of you have this joint account. What USCIS wants to see is proof that maybe bills are being paid with the account, showing that the debit card is being used by two different people, because some bank statements will indicate which debit card is being used. So they really want to see that you guys are working together as a couple, as a team. You have joint utility bills. You have you're filing your taxes together. You're holding yourself out to the public to be a couple. And talking about holding yourself out to be a public, out in the public, having selfies are not as selfies of both you and your spouse are not as convincing as pictures that show that both of you are, with people in public, going for weddings. People know you as a couple. You're going for barbecues. You're traveling on vacation. A slice of your life. What is it that you do together? So if you have picked selfies all the time, that's really not helpful, because it doesn't give USCIS a slice of your life. So now I want to caution you guys. Sometimes your work, when you file the I-751, and you it's the I-751, the green card is expiring, right? A lot of people make this mistake. They renew it. They file an I-90 to renew the green card. That's the wrong form. The I-90 is for people who have a 10-year green card, right? And they're looking to renew their 10-year green card, or they've lost their green card and they're looking to replace it, or there's a mistake on their green card and they're looking to correct it. So the I-751, for those who got married and got a 2-year green card, you're not supposed to file the I-90. You're supposed to file the I-751. And this is really, really important, because there's so many people making these mistakes. So what happens if the relationship doesn't work out? Maybe it's abusive. Maybe you just can't live together because it's just not working out. It doesn't even have to be abusive. Well, if your relationship is not working out and you have a temporary green card, you'll be glad to know that you can file waivers. There are 4 different types of waivers. Hi, Rohit. How are you? Thank you for joining me from India. There are 4 different types of waivers that you can file to get your 10-year green card without using, without your spouse. And so I'm going to go into that in a little bit, okay? So the first waiver I'm going to discuss is the waiver of divorce. The marriage didn't work out. Everybody decides, it's best to part ways. You can file the I-751, remove the conditions on your own using the waiver of divorce. But remember, the waiver of divorce requires you to prove that the marriage was a bona fide marriage, that it was a real marriage, that you married your spouse for love or for companionship and not just for immigration benefits. So what I discussed about with regards to proving a bona fide marriage, you have to, present all these documents. And remember, this is really important. Don't send the same old documents without adding additional documents. You can send the old ones that you submitted when you got the temporary green card, but you must remember that USCIS is really most interested in the period between when you got your green card and the expiration of your green card. Now, if you're filing a divorce and you present, the information showing that it was a valid marriage, right? Another thing you also have to show them is a divorce certificate. So that's why when I hear clients or I see clients really getting agitated because their spouse wants to divorce them, I tell you, why not? Let them go ahead. And it's important to actually get started with the divorce really quickly because in some counties, divorce process is taking a long time. And you really want to get that divorce decree, ideally before you file the I-751. Now, sometimes you're not able to get the divorce decree before you file the I-751 and you go ahead and you file it. But remember, you're probably going to receive a request for evidence asking for the divorce decree. If you don't have the divorce decree, your I-751 will be denied. So if your relationship is not working out, go ahead and get the divorce. Don't be worried about that because when you get a divorce, all you have to prove is that it was a bona fide marriage. Then put all your, all the evidence you have showing that it was a real legitimate marriage. All right. Now, another thing and the good thing about the divorce decree is you don't have to wait until 90 days before the expiration. If the divorce is through, go ahead and file it. Go ahead and file your I-751. The other waiver, which is the waiver of extreme cruelty and physical abuse, right? Same thing. You don't have to wait until the green card is getting ready to expire because if you're in an abusive relationship and you can't, it's abusive, you can't at that point file to remove the conditions on your own without waiting for the 2 years. And the good thing about the extreme cruelty and abuse waiver is that once you get your green card, your permanent green card, you can apply for naturalization within 3 years. Within 3 years of when you first received the green card. And for a lot of people, waiting for the I-751 to be approved rolls into the 3rd year so they can at the same time file for naturalization. And typically what happens is that USCIS will, that typically will make actually the process go faster. So USCIS will schedule the I-751 interview and maybe sometimes at the same time as they schedule the naturalization, depending on which office it is. So that's a good part. I mean, that's really an advantage of using the extreme cruelty and abuse waiver. And of course, you still have to show that it was a legitimate, real, good faith marriage. That doesn't go away. So, and that's where a lot of people get stuck, right? Because they're able to prove abuse, but if you can't show that it's a real marriage, that you marry this person for love, for companionship, you want to build a life with them, it doesn't matter how bad the abuse is. Because a lot of people that get abused in a sham marriage, right? And, the abuse is typically, threats to call USCIS, to tell them it's a sham marriage, or, even physical abuse. It doesn't matter. You must prove a bona fide relationship. You must, because you can't move past to showing abuse unless you're able to show that it was a real relationship, and that you entered into the relationship with your spouse, for the right reasons, which are the legal reasons. Okay. So now, the extreme abuse and the physical, the extreme cruelty and physical abuse, like I said, you don't have to wait for 2 years for the green card to expire before you can file it. As soon as the relationship is unbearable to you, as soon as you're suffering abuse, go ahead and put it in. Now, remember that USCIS is going to look, they're going to need proof of the abuse. And one of the, the biggest proofs that we submit is the declaration, the letter or the write-up from the client explaining what they have been going through, the abuse they went through, with details, with evidence if you have it. And if you don't have it, do your best. Figure out a way to think outside the box. That's the one thing our firm is really good at, thinking outside the box, helping clients gather evidence when they think they have no evidence. You'd be surprised at all the evidence that you have, even though you think you don't have enough, So that's the second. Then the third is death. If the US citizen or the green card holder dies, well, clearly you cannot, remove the conditions with them. So that's a waiver. You can go ahead and, show the death certificate to show that they're dead. They can no longer join you to remove the conditions, but you also still have to prove that it was a bona fide marriage. I tell you guys, there's nothing as important in a marital green card case as much as proving that it was a real marriage. And the consequences for a sham marriage, I keep telling you guys, is so severe. It's a permanent bar. And what a permanent bar means is that you will not be able to get a green card ever. Very limited circumstances that, there's no waiver for it. There's no waiver for a sham marriage. So there are people, when immigrants come to the United States, there are people who have all kinds of bad advice to give them. And when I come on here, part of the reasons I do this is to give you the information that is true and accurate. So if you're an immigrant who's just coming to the United States, please don't let anybody talk you into a sham marriage. There's a permanent bar. It means that nobody, your children can't file for you. Your next spouse cannot file for you, because as long as USCIS has a finding of a sham marriage, or that you didn't meet, even that you didn't meet your burden of proof, that's a problem. Now, the last waiver that I want to discuss is the waiver of extreme hardship. Now, this waiver just requires you to show that you would suffer extreme hardship, or somebody, a family member, would suffer extreme hardship if you had to leave the country. And this is actually the only waiver that does not necessarily require you to prove a bona fide relationship. So, what are the steps for filing the I-751? Like I said, you file the I-751, you get a receipt, you get an extension letter, right? In the past, it used to be 12 months extension letter, then it went to 24 months. Now it's 48 months. So basically, USCIS is giving themselves 48 months to make a decision whether or not you get your 10-year green card. We're hoping that they're not going to actually take all of the 48 months. We're hoping that you get your green card in less period than that. So far, we've been able to, we've gotten our requests, our I-751 cases approved in less time. But remember, the 48 months extension just came in, I think it was last year. So we don't know how that's going to go. Now, once you get the receipt, that extension letter, right? That with your expired green card puts your green card status as current, right? Now, remember, even with an expired green card, it does not mean that you're no longer a green card holder. It means you have an expired green card. You cannot prove that you're a green card holder, but you are not out of status. Or the only person that can take away your green card is a judge. but you want to make sure that you're in status, your green card is, is valid all the time. Just like you want to make sure that your driver's license is valid. You don't want to drive around with an expired driver's license. You're likely not able to work with an expired green card. Most employers won't accept that. But with the 48-month extension letter, whatever extension letter you have, that together allows you to travel and leave the country. It allows you to work. It's just as if your green card was reinstated while you wait for USCIS to adjudicate on your I-751 petition. Now, let's see if I have any questions. Let's see. Rohit Niral says, for Indian immigrants, the options are limited as the green card backlog is long. Rohit, it depends. If it's a family-based petition, it doesn't matter where you're from in terms of I-751s. Yes, it matters where you're from in terms of consular processing and all that. Yes, but if you already have a green card and you're looking to remove the conditions from your green card, it doesn't matter where you're from. The backlog is the same for everybody. That's why you get the 48-month extension letter. So Althea Brown says, hi, if you're married to a green card holder, can he file for you? Althea, that's a really great question. So a green card holder can file for you. Let's talk about a marriage-based case. They can file for you in a marriage-based case if you are in legal status, right? So say you're here on an F1 visa and you're still currently in status, the green card holder can file for you and you can adjust your status. However, if you're here, say on a B1, B2, and your status has, expired, well, you're not going to be able to adjust your status because you are not in a valid status. So typically what we say is we tell the green card holder has to become citizen so that they can now, apply for their spouse. Or there are times when we go ahead and file the I-130 if maybe the green card holder is almost getting ready to naturalize, so that once they naturalize, we then file the I-485 and allow them to adjust their status. Also, if you're filing, say VAWA, and you're married to a green card holder who's been abusive, you may not be able to adjust your status right away because the priority date is not current. But once it becomes current, you can adjust your status. So, in a nutshell, Althea, whether a green card holder can file for you depends on your legal status, and it also depends on the type of application you're looking to file. Okay, I hope that is helpful to you. So Grand Duchess says, hello, steps to proceed 60 days from conditions be removed. However, separated, abuse relationship. So Grand Duchess 1, I think you're saying that you have 60 days before the green card expires and you're separated and there's an abusive relationship. That's what I'm getting, because sometimes I have to read between the lines with what are some of the messages you guys send because it's shorthand. So Grand Duchess, your case is exactly what the waivers are for. So if you're separated from your spouse and you have 60 more days to remove the conditions, go ahead and do it now, because there's no waiting period. You don't have to wait for your green card to expire or for it to be close to expiring if the relationship is abusive. And you can get your green card and you can remove the conditions all by yourself by using that waiver. Okay, it waives the need to have a joint filing by your spouse. All right, so okay, I think that's all the questions I got on YouTube and Facebook. Let's see if I have any questions on Instagram. I don't really think my Instagram is really moving, so let's see. Guys, Instagram, the writing is really tiny, so forgive me if I don't get to some of your questions. So Ayemuktal777 says, can one file I-751 based on hardship and you are earlier been denied and couldn't refile when the family facing hardship and the spouse is incapacitated with health issues and she is the sponsor? Okay, this is a very loaded question, and I'm not really sure I understand what you're saying. But you can file I-751 based on hardship. But remember, the approval is not automatic because you say there's a hardship. USCIS has to agree that there's a hardship. So this is something that you might want to talk to a lawyer about to make sure that you can make a good case for hardship. So if you want us to assist you, we're happy to do so. 973-993-1900. Let's see. Dave IBK says, do filing a divorce after my prima facie extend prolong the processing time for my pending VAWA application? Dave IBK, I love that question. And filing a divorce has no relevance to how fast your VAWA goes, how slow it goes. Nothing has no relevance to it. The only thing that you need to know about a divorce is when you file a divorce, you must file your VAWA within 2 years of filing the divorce. So other than that, it really doesn't have anything to do with the processing time of your VAWA application. I hope that answers your question. So Prince Chooks says, so is it better to convert the conditional green card to VAWA when abused? No. Or removal of conditions with VAWA or abuse? Okay, Prince Chooks, that's a really great question because this is really confusing for a lot of people. So that I'm really happy you asked this, so let me answer it. So with the VAWA case, you haven't gotten a green card. You file VAWA, you're claiming abuse, you have not gotten a green card. So when you haven't gotten a green card and you're in a marital relationship with a U.S. citizen or a green card holder, what you file is VAWA, Violence Against Women's Act. Now, when you've gotten your temporary green card and there's abuse in your relationship, and you know what you're going to do is use the waiver, which is attached to the I-751, to remove the conditions. So even though VAWA and the I-751 abuse waiver they're actually the same kind of thing, because I've heard people call I-751 VAWA as well, but it's not. They're not. So VAWA is when you suffer abuse, and I'm talking in the context of a marital relationship, because you can also file VAWA if you're a child who has been abused by a U.S. citizen or green card parent, or if you're a U.S. citizen, if you're a parent who's U.S. citizen child over the age of 21 has abused them, you can also file VAWA. But right now I'm talking about the marital relationship. So when you file VAWA, it's because you're married to a U.S. citizen or a green card holder, and you're in an abusive relationship with them, either physical abuse or psychological, emotional, etc. type of abuse, but you haven't gotten a green card. Because if you get a green card and it's a 2-year green card and you need to remove the conditions and there's abuse, then you're doing it on a waiver, okay? But the types of abuse that we look at in VAWA and the types we look at when we're doing a removal based on abuse, it's the same abuse, it's the same abuse, psychological abuse, verbal abuse, emotional abuse, financial abuse, sexual abuse, physical abuse. It's all abuse. All right. So thank you for that question, Prince Chooks. And I think that's it. Let's see if I have another question. Guys, forgive I'm a little, my voice is a little not there today, and I'm a little tired. So let's see. Tasha says, hello, Quinn. Is there any improvement at the Atlanta field office? Tasha, honestly, I haven't seen any improvement in any of the offices we're working with. Sometimes they move things. We keep getting letters saying they're moving into another field office. The only places that we're getting real fast movement on the cases are naturalization cases. They're moving really fast on those. Even I-130 adjustment of status, some of them, they're really moving fast on those. But sometimes it all depends, So I really can't promise you that there's much improvement in any particular office. All right, Moha Sekudaki says, if I decide to file for VAWA, how does it affect me getting a green card again if it fails to go through? So Moha Sekudaki, that is a great question. Like with every denial, not just VAWA, every denial, it depends on why the case was denied, right? Um, if your case is being denied because it's a sham marriage, like I've said it before, you're likely gonna find it really hard to get a green card because there are no waivers for those. Now, in a VAWA case, there are no interviews in VAWA itself. But if for any reason, say you had an interview and you were married, you had an interview, it didn't work out, then you filed VAWA, and there's already been findings of a sham marriage, that's a bar. If you file VAWA and the reason is just that you didn't meet your burden of proof because you couldn't prove abuse or whatever, you can get a green card in any other ways, depending on whether that new pathway allows you to get a green card when you're out of status. Okay, I hope that was helpful. All right, so guys, it's 4:55. I have to interview somebody at 5 o'clock, so I'm gonna head out. But it was a pleasure talking to you guys today, and I hope you guys all have a great week, and I will be back again to discuss more immigration stuff. So if you're looking for an immigration lawyer who's experienced, we do VAWA, U visa, T visa, adjustment of status, K visa, call my office 973-993-1900. If you have an order of deportation, we're working on a lot of cancellation of removals, prosecutorial discretion requests. Call us. We want to help you and we want to assist you. Take care. Bye-bye.